Good morning. My name is Sabrina, and I am here with Travis and Philip. We are legalized negligence discussing Florida Statute 768.21, subsection 8. And today we are going to talk about the 2021 analysis of House Bill 651 by Representative Spencer Roach.
Okay, and I'm going to just put our disclaimer up front here because I usually forget and do it at the very end. Nobody here is an attorney. Everything that we say is just information we've learned since our loved ones have died, and we've had to dig through the law to find this information. So we not only ask you, but we encourage you to do your own research. Take anything that we say and look it up yourself. We're not giving legal advice. We're just talking about our experience since our loved one died. So I'm going to go ahead and pop this bill up on the screen so everybody can see it. Let me know when it's there.
It's there.
Okay. Does anybody want to start, or I'll be happy to start, or whatever you want to do?
No, go
So
ahead.
I'm happy to talk a little bit about it. I'm really glad to cover this today. I realize this analysis is from 2021, and it's also on a bill that was for parents who lose an adult child. But I think it's a really important piece of information that we can use going forward for both sides of the fight. In changing or ending this law. So I'm happy to be discussing this today.
Yeah, you're exactly right, Sabrina, because this is an insight into how these people think. We're getting a peek inside their head and what the opposition is to getting rid of subsection 8. So let's just start at the very top where I've got it highlighted. I hope you can see my cursor moving across there. HB 651, the title of it, Recovery of Damages in Claims of Medical Negligence. So they're recognizing that there was negligence that occurred. I mean, it's in the title of the bill. So the very first paragraph in this summary analysis is a wrongful death action arises when a person dies from injury sustained as a result of a wrongful act or omission by the defendant. Right there, they're telling you that it's wrongful. They recognize on its face that this person did not die of natural causes or an act of God or some sort of accident that happens in life. This was a wrongful death. Anytime either one of you has something that you want to add, please jump in and do it. Otherwise, I'll just keep going here. And then they talk about what you can recover and what you can't recover. So let me back up just a minute. And we've heard the argument from lobbyists that there was a time when we were at common law that you couldn't recover damages at all. No family member could. And then the legislature gave certain people, and we'll get into that a little further down here, gave certain people standing to be able to sue for damages, both economic and non-economic. And for people who are new to this, economic would be any damages, let's say that a parent might be contributing to a child, or a child might be contributing to a parent, or a spouse to a spouse, anything that has a dollar value to it. Like if they owned a business and the family relied on that business income, that would be an economic damage. A non-economic damage is like companionship. How do you put a price on companionship? How do you put a price on mental pain and suffering? How do you put a price on those? So you can't. So they call them non-economic damages. And it says in an ordinary wrongful death action, okay, recognize ordinary wrongful death, such as a suit based on the death caused by an automobile accident. So these are one of the things that happen in life, still due to somebody's negligence, whether intentional or not. Somebody was negligent and caused an innocent person to die. In those cases, the legislature is referring to it as an ordinary wrongful death. And you go down to the last sentence in that paragraph, and it says, however, when a wrongful death action is based on a medical malpractice claim, parents cannot recover for the mental pain and suffering of the loss of an adult child. And as we know now, because of subsection 8, neither can an adult child recover for the loss of a parent, a single parent. So right at the very beginning, the legislature separated out who can and who cannot recover damages. So you got to wonder why. Do you think they did it on their own? Were a bunch of lawmakers sitting around and say, hey, before we pass this, let's carve out the medical community so that those doctors and nurses can't be sued for negligence? Or do you suppose that maybe doctors, nurses, and insurance companies that provide medical malpractice insurance might have had a hand in that? That
They definitely had a hand.
Say again?
They definitely had a hand. They led the legislature to what they wanted.
And I would take it a step further. I would say that they're the ones who created the crisis, or the supposed crisis. They're the ones who went to the legislature saying, you know, doctors are fleeing the state, and it's all because their malpractice premiums are too high. Now, before I go on with this, I'd like to share, I'm going to take this one down, and there's another video that I would like to share from a recent, let me find it here. That's a legalized negligence. Let's see, if this is the one I want. Nope. Bear with me just a second. Let me find this video.
But while you find that, I want to say that they are 100% in control of the crisis. Because if the insurance company is a doctor's own company, like the doctor's company, they're basically self-insuring, and yet they're the same ones that are causing the tort, the wrongful action. So you got the physicians billing themselves insurance, and then they're also the same ones that are causing the issue of a claim. So they're 100% involved in the crisis.
You're exactly right. I'm going to go ahead. Is that sharing on the screen, Travis? Are you seeing Tamika and that reporter sitting there?
No, I don't.
Okay. Let me get that one up. For some reason, there it is. That I couldn't figure out which screen it was on. Okay,
All
it
right.
should be up there now. I'm going to start this at the 4-minute mark and run it for about a minute or so, because this is where the reporter speaks to an attorney named Andy Boland. Well, for whatever
like
reason,
I said, it's a balancing act, and anytime you're correct under the circumstances that we talked about.
Can you help me understand why that is?
Yeah, like I said, it's a balancing act, and anytime you're looking at any segment of the law, there has to be a line drawn somewhere, and the legislature chose to draw it where it is.
Ybor City Attorney Andy Boland has been representing Florida doctors and hospitals for decades, healthcare providers who've been protected by this law since the state legislature passed it in 1990.
They recognized a perceived medical malpractice crisis that was looming in the state.
Lawmakers were worried that doctors would leave Florida.
Let's hold on right there. He said they recognized a perceived crisis that was looming. Now that tells me there was no crisis at the time.
Perceived.
So it wasn't like a hurricane went through and you could look out your window and see the damage. The medical community, and I'm including the insurance companies that provide malpractice insurance, they went to the legislature and they said, hey, let me tell you what's going on. This is looming out there. It's on the horizon. We believe it's going to happen. And they persuaded the legislature to write a law. Okay. So just keep that in mind as you watch the rest of this.
If malpractice insurance rates spiked here, not ideal for a state popular with retirees.
Legislation was hearing very strongly from the medical community. If you don't pass these laws, we will not come to your state, we will not stay in your state, or we won't insure doctors in your state at a reasonable rate.
Does that sound like coercion to you?
I couldn't hear the audio.
You can't?
I can hear it. I can't hear it well enough.
Oh, Sabrina, how's the audio on your end?
It was low, but I could hear it, but it wasn't very loud.
Well, maybe it's controlled by my volume. We'll see if that brings it up some. What he said was that the insurance companies went to the legislature and said, we won't, or the medical community went to the legislature and said, we won't bring doctors to your state. And let me go back and play that.
So we found
From the medical community, if you don't
rates spiked here, not ideal for a state popular with retirees.
legislation was hearing very strongly from the medical community. If you don't pass these laws, we will not come to your state, we will not stay in your state, or we won't insure doctors in your state at a reasonable rate.
Could you hear that better?
Yes, coercion.
That is coercion. That is absolute coercion. That we're going to hold you hostage until you pass the legislation that we want. Now, that second attorney there that just said that, he represents families. The first attorney represents the other side. Let me continue with this for just another minute.
So we fact checked whether that's still a legit concern. Data from a 2022 Florida Department of Health report indicates state law hasn't stopped doctors from leaving. Over the past 10 years, the number of
I'm going to stop it again. What she just said is this law that was passed 33 years ago has not stopped doctors from leaving. So if they were leaving back then, and the legislature thought the remedy was to create subsection 8, clearly the remedy hasn't worked. So it's time to get rid of it.
The law had no effect.
The law had absolutely no effect on anything.
doctors planning to move out of Florida has increased 57%. Nearly 5% of physicians surveyed said they plan to leave Florida in the next 5 years. Their top reason for leaving was family. Financial reasons clocked in at second, barely above looking for a change. Fewer than 7% blamed liability exposure.
I think it's dangerous to start removing those protections and then finding out whether or not, in fact, we needed them.
It's dangerous to start removing the protections and then finding out. You've had 33 years to find it out. People have lived.
Here's another interesting point on that. Remember the statistic of what percentage of doctors per 100 was causing the majority of the medical malpractice? You see how close to the 6% of doctors leaving that is?
Yeah, it was 4% of doctors were causing 42% of malpractice payouts. And this has
and you got 6% wanting to leave. That's pretty close to 4.
Yeah, exactly. After they had been sued enough times, they were going, "Well, I don't want to get sued here anymore. I'll go somewhere else."
Yep.
Number of active physicians in Florida is average compared to the rest of the country. A 2021 report from the Association of American Medical Colleges ranks Florida right in the middle, number 25 out of 50 states, plus DC and Puerto Rico.
Medical malpractice premiums are on the rise, and we're talking to our clients who are seeing 40 and 50% increases year over year in their medical malpractice premiums.
Well, I wanted to stop you there for a sec because according to data from the Medical Liability Monitor, over the past 3 years, The majority of medical liability insurers did not increase Florida doctors' rates.
So all I can tell you is what I hear from my clients, and what they are seeing is increases year over year, especially when you talk about high risk specialties like obstetricians and surgeons. Their medical malpractice rates are certainly a strain.
So what options do families have if this law
That right there.
court system?
That part, when he says that's what he's hearing from his clients, he couldn't answer her question.
Exactly right.
What you're hearing from your clients is not a good enough reason to keep a law in place or use that reason to keep a law in place when it's just what you're hearing from your clients. We could say what we're hearing too, but when it comes down to facts, that is a political way to create an agenda to convince lawmakers to vote a certain way without having facts.
His data set is only his clients. And of his clients, the ones that are complaining to him.
In other words,
Exactly.
he's not looking at data. He's listening to his client's interpretation of data.
And the other thing is, and forgive me if I'm wrong, I know you guys will fix it. If he had 4 clients complain last year of their rates, and he had 8 clients complain this year of their rates, he'd say 100% more of his clients complain, correct?
Yeah, that would be a
Wasn't that how the percentage, isn't that how it works?
Well, if it was 4 of clients last year complained and 8 this year complained, that's a 200% increase.
Okay, so that's all it takes. He's putting it all on his clients. We don't know how many that is. The percentage could be way off to what it really is. It's a weak argument. It is a weak argument. Okay, that's what I had to say.
All right. That was what I wanted to share out of that. I think Jenna did a great, that's probably one of the best stories I've seen done on subsection 8. And you can find it at our Facebook page. Let me pull it up here. Might as well share that while I'm at it. Oh, I know what I have to do. Hang on a minute. I've got way too many things opened here.
Well, if they go to go.legalizeednegligence.com/FB, that'll take them to the website, to the Facebook page.
Now, let me see if it shows up. There we go.
I'm really glad we're doing this because, it's really easy for people to say to other advocates, you need to do this, you need to do that. That creates a herd-like atmosphere of a bunch of people doing things that they may or may not understand. And one thing I want to tell these listeners is that Travis, Philip, and myself are always here for anyone that has questions. Before you do something that you may not feel comfortable with, you may not understand, reach out to any of us and we'll help you. And if I can't, I'll refer you to one of them. If they can't, they'll refer you to someone who can't. And we're here because we want, as far as I know, our goal is for people when they approach legislators, we want accurate information. We want accurate numbers with accurate supporting evidence, so to speak. And that Mr. Bolin could not provide that in his argument. And to me, it makes him look weak. So yeah. I just want to send that reminder out there as well.
Yeah, and this is our Facebook page. Just go to Facebook and we're Legalized Negligence. That's probably all you really have to type in, but legalized negligence, the state of Florida versus the people. But yeah, basically what you just said, Sabrina, is we want the truth. If there really is a crisis, that's fine. We'll figure out a way to deal with it. But don't tell people there's a crisis when it's all based on insurance companies being able to retain more of the premiums that doctors pay. They just want to take in the premiums and then limit their liability having to pay it out. That's what it comes down to. And the legislature, in my view, did not take care of the people who put them into office. They listened to the people with deep pockets, and they sponsored and passed legislation that interfered with our rights to be able to recover in a tort claim. So I'll put that bill back up on the screen so we can get on with that. I know Sabrina's getting close to running out of time here, if she hasn't already.
No, I'm here.
Okay.
I'll
Right.
be here a few more.
So we covered down there, and I'll scroll on down to where I highlighted. This was something that I thought was very interesting, and it's really doesn't have anything to do with what's written in this, but it says this document does not reflect the intent or official position of the bill sponsor. Well, what that says to me is that a true statesman, a legislator that acted as a true statesman, takes his constituents' concerns and passes a law on their behalf, even if he doesn't like it. Even if he says, well, I think everybody, nobody should be able to recover damages, but the majority of my constituency believes different. I think it's interesting that they would put that on there.
We're basically saying that Rep. Roach could be the person who's for the people, despite what their analysis says.
Yeah, exactly. Exactly. Okay. I don't want to, take over this whole thing. Anytime y'all have something to add, please do. Now I kind of get into their definitions of wrongful death. They say here a wrongful death action arises when a person dies from injury sustained as a result of an act or omission by the defendant. And then that whole thing about it, when we were at common law, nobody could recover for wrongful deaths. Then it says, but then the states began to enact wrongful death statutes to create a civil right to recover when the would-be plaintiff dies, shifting the resulting losses from the decedent's survivors to the wrongdoing. And basically what that's saying is that if malpractice had occurred and you survived it, you could sue the doctor. But before all of this, once you died, none of your family members could sue. But then the legislature decided to allow everybody to sue in a tort claim with the exception of the medical community. They carved the medical community out and said, we're going to protect you from this. We're going to let other family members recover pain and suffering damages, non-economic damages, but we're not going to let that happen to the medical community. And they base that on, like what Andy Boland said, a perceived threat that was looming. Not anything that actually happened, but a perceived threat that was actually looming off on the horizon. Now, I can tell you from my own research that this same argument has been around since the mid-70s in other states, pretty much all the other states. And what it comes down to is, to say it in a very simple way, the insurance companies don't put enough money into their reserves when they bring in medical malpractice premiums to cover the actual malpractice that happens. And I learned this lesson from an insurance agent who explained to me that your insurance rates can go up if, let's say that you have a hailstorm and suddenly a bunch of cars in your state got damaged in that hailstorm. And now, does the insurance company have enough money to cover all of those cars when normally they would just have to cover claims on a few cars? So the same applies to medical malpractice premiums. These doctors are paying in, The insurance company is making money off of it, and they simply did not, the insurance companies did not set aside enough money to cover themselves, and they created the crisis and then went to the legislature and tried to tell them it was because there were too many frivolous lawsuits. And the fact is, and I can't remember who said this, but it was within the last week or so. I think it was a lobbyist that we were talking to. Said that frivolous lawsuits rarely ever happen. Oh, I know what it was. It was in that video that Travis sent to us
Yes.
to watch.
Mhm.
That's where it was. They simply do not happen because
They're far too expensive to
exactly.
bring for a frivolous lawsuit to even be an issue.
Yeah.
Well, you got two factors. You got the certification that rules out frivolous, and then let's say you do have a cause, you have the cost that rules out even the good causes because the recovery may not be enough.
Yeah, what happens is you get some weird, case that comes along, and then that's the one that gets all the headlines. If you, I think I shared the story about the woman who burnt herself with a McDonald's coffee 2 or 3 decades ago. That was a one where what they didn't do is tell you what actually happened in the end. McDonald's settled for her medical cost. She didn't get all these millions that originally happened. But see, the news doesn't come back and tell you the ending of that story. So this whole thing about frivolous lawsuits is nonsense, and the lobbyists use it to keep the legislators. And don't forget, there are a new crop of legislators coming in with every election. So the people who passed the law, subsection 8 originally back in 1990, they're not in the game anymore. That was 33 years ago. I mean, they've gone on to bigger and better things. So you get these newbies coming in, and I mean, now we're 33 years after the fact. Have they done the research? Have they read the task force reports? Have they looked at the information from across the country from the mid 70s where it started in California? Few of them have. Only a handful of them spend time looking at it. So what do? They vote the way that they have voted in every year before. When it comes, well, what did the last session do? Oh, they voted to keep it in place. Okay, well, that's what I'll do. I'll vote to keep it in place until people like us come along and start creating some noise about it. And now that we're bringing all this information to their attention, maybe we can get them to look at the other side of the story. Sorry, I didn't mean to go on a rant there, but it just started coming out.
No, I agree with you. It's all about the approach. And, something pretty special happened with me lately. I found an article from 1997 regarding a woman who lost her father. And there was the bills back in 1997. Well, I found her online and I reached out to her, and she actually wrote me back, told me everything that happened to her dad. He had an aneurysm in her car after they discharged him from the hospital. And she fought and fought and fought this law, and now she's 60 something and she's got a lot of health issues, and she apologized about giving up. And I said, no, you never gave up. You fought when it happened to your dad. And I said a better way to consider it is you've just passed that torch on to other families, but don't ever think you gave up. You have to take care of yourself. This fight is not easy. Nobody said it was going to be. But I told her, for the fact that I, could come across her story this many years later is pretty powerful. And she thanked me for that, for reassuring her that she didn't give up. And I think it's important to recognize too that, for so long, people have been bringing bills and creating fights, and eventually we will have the bills with the right fights, and everything will align to the point where they understand us, and that's why I think it's so important that before we go to Tallahassee and make an argument, we have to understand what we're talking about. And I'll be the first one to admit that I may not have understood everything when I started. I understand a lot more today than I did then, and a lot of it is because of Philip and Travis. So it's so important to be accurate. and to know your fight, because the last thing I want to happen is to be up there in Tallahassee and some surprise come up, like, you know, we want to add caps. That should not be a surprise to anyone. No one should have to be like, oh my gosh, really? Like, we should all prepare for that. Let's talk about caps sometime, and let's talk about, if they tried to present that argument, what do we say back? We need to be ahead of the game, ready for whatever they bring. And in that aspect, I think it will help us create a better and stronger, more persuasive fight, like the lobbyists are doing now to lawmakers. Now it's our turn to do that and get through to them. I didn't mean to go on a rant either.
No,
but I think
that's fine. You bring up a very valid point there. It's like, you got to know your material and you got to know your audience. And, you know, I'm not knocking the people that, you know, walk the streets with their signs and all that. I think that's a necessary part of it to bring awareness to the people that are seeing them do it. But to deal with the legislators, the one that has the power to alter this law, those signs and placards aren't going to help a bit. It's the kind of work that we've been doing behind the scenes and sending information to and speaking with and meeting with legislators that makes the difference. We win it on their battleground. And
absolutely.
you know, I think that's what we're doing. And I'll just touch real quick on caps in case people don't know what a cap is, because I know there's a lot of us that have been in this for a while, but there's also new people coming along all the time.
Philip, I don't mean to interrupt you guys. I'm gonna hop off and go pick my car up. I had some new tires put on. But can y'all keep going, please?
Sure.
You guys are doing
Absolutely.
a great job. And I'm sorry I have to leave early. But thank you so much. And keep going.
Have a good day.
Bye-bye.
Thank you. Bye, guys.
Bye. But caps are, the legislature will say that you can't sue for any more than this. In other words, they cap it at a certain place. So what the lobbyists want to do is, the lobbyists for the insurance companies, what they want to do is say, we're going to you can sue for malpractice, but we're going to put a $200,000 or $250,000 or even $500,000 cap on that. Well, that might sound good. You can say, oh, I can sue for $500,000. But what happens when it costs an attorney $200,000 to $300,000 just to prepare the case and get it before a jury? So right there, half of your $500,000 is gone just for him to break even. So now and then he's got to make a profit on top of that. So by the time he gets paid his 30 or 40%, whatever it is that malpractice attorneys bill down there, then what are you going to be left with? You know, $50,000 or $60,000, maybe $100,000 at best. But that's, to me, is not the point. The point is accountability and justice. You know, the whole point of being able to bring these cases, and this is my view only, the whole point of being able to bring these cases into a civil court is to expose the malpractice to the public. Because right now our only remedy is to bring it to the Department of Health, and it's all done in secret. It's all done behind closed locked doors. Nobody knows what's going on. They won't tell you why they closed their case. But if we can get it into civil court where it's public, then the malpractice gets exposed to the public. Yeah. And if the doctor is successful, well, good for him. He proved that he didn't commit medical malpractice. But if he's not successful and the plaintiff wins, then it gets exposed to the state and to the people what kind of malpractice is occurring in Florida.
Right. But remember that the Department of Health and ACA, they don't represent the interests of the people.
Correct.
They represent the interests of the state.
Negligence is a legal cause of the damage if it directly and in natural and continuous sequence produces or contributes substantially to producing the damage. A recent study showed that over 60% of the physicians who were sued believed that the resolutions of those cases were fair and appropriate. And all of those resolutions, or not all of them, but the vast majority of them would have involved verdicts or settlements. You can't bring a lawsuit in Florida against a rheumatologist, a board certified rheumatologist, without having an expert witness who is him or herself also a board certified rheumatologist. And the notion that there are frivolous lawsuits, candidly, let me tell you, let me dissuade you from that. That is not true. There are very, very, very few frivolous lawsuits. Lawsuits to be prosecuted by plaintiff attorneys are just too expensive for that. They can't afford to bring frivolous lawsuits. As I mentioned earlier, only 0.4% of the cases are considered to have insignificant injuries. And the notion that all you need is an angry patient and a lawyer, and therefore you're going to have a lawsuit, is just nuts. The amount of money that it costs to bring these things is mind-boggling. Now, we've talked about experts and how important they are. We haven't really talked about it in the context of this issue, proximate cause. An expert can come in and say, Dr. So-and-so's care and treatment caused this injury. There's your proximate cause. And you would expect that from the expert that the other guy hired to testify against you. What you may not expect is that the guy down the street from you who belongs to your club has seen the patient since you have, and he or she agrees with the same thing that the other expert does.
Okay, now it's getting into something different, but I thought it was important for people to hear this come from an attorney about the frivolous lawsuit. So every time you hear a lobbyist say that this law was created, subsection 8 was created in order to keep people from filing frivolous lawsuits, now you heard it from the other side.
Right. And then again, only the lawsuits that move forward are those with significant harm, because an insignificant harm doesn't have the payout to make the suit process worth it.
Exactly.
So there's more malpractice occurring than what goes to court.
Yeah, exactly. Well, let me put this bill back up. We've already almost at an hour or so. So let me put this bill back up and we can get on through it. I'm really only going over the parts that I've highlighted because so much of this just kind of explains what those parts mean. Are you able to see that?
It's loading. Okay, now I can.
Okay. Under Florida's Wrongful Death Act, when a person caused damage, here, I've already covered that. Okay, so here it tells you, well, basically this is everything that we've been saying, but I do want to get into where they talk about the Mizrahi case, and that's what we're coming up on here in a minute. Medical negligence exception to a wrongful death act. The act evolved from the medical malpractice tort reform of the late 80s and early 1990s, prior to which there were limitations on who could bring any kind of wrongful death lawsuit for damages. And then at the bottom of that, I highlighted the statute expressly excluded non-economic damages in medical malpractice claims. So, but what that's saying is that the statute included that in malpractice claims, you could not sue for pain and suffering, loss of consortium, companionship. And you got to ask yourself why. You know, that's what jumps off the page at me. Why would you carve out the medical community? You know, if a drunk driver kills your, widowed mother, can you not sue for that pain? Well, of course you can. You can include that pain and suffering for the loss of your loved one, but not medical malpractice. Well, again, I'll say it. It wasn't the legislators that were sitting around saying, "Oh, we need to carve out, this group of doctors and nurses." It was the representatives of the doctors and nurses going to the legislators and saying, "We don't want to be included in these tort claims." And I'll leave it up to everyone to figure out on their own why they think that was that the legislators agreed. I've got my own opinion, but it's an opinion. But then it says the legislature reasoned that by protecting medical providers from increased malpractice suit exposure and escalating liability insurance rates, it would encourage more physicians and this is important to listen to what's written between the lines. It would encourage more physicians to practice in the state and lower the cost of health care by reducing malpractice premiums. Well, let's take that first part. It would encourage more physicians to practice in the state. So, in other words, if I can't get sued for my negligence, or if I don't want to be sued for my negligence where it causes a death, I can work in Florida and I'm covered. Think
Yeah.
about that.
It would also make theoretically more doctors available. So the wait to see a doctor isn't that long, but we all know that we have to wait months and months as is.
Well,
So again, this didn't fulfill that goal either.
yeah, and so let's get to the second part of that sentence there where it says, and lower the cost of health care by reducing malpractice premiums. So they're trying to tell you, we're going to throw you a crumb here. We're going to lower your cost of health care insurance, or lower the cost of health care by lowering malpractice premiums. Now, I am going to put a challenge out to anyone. I want anyone to be able to tell me if their health care coverage has gotten any cheaper over the last 33 years. Is healthcare more expensive now than it was 33 years ago, or is it less expensive? So if that was one of the goals of subsection 8, was to make healthcare more affordable and more available, I'd like to know if that actually ever happened. Because once again, if it hasn't, then the legislature has a duty to the people to say this law isn't working. We tried something and it isn't working. Do I need to beat that horse anymore, Travis, or have I made my point?
You made your point. I'm thinking of that as a contract almost. It's not a contract, but if it could be interpreted to be, because they're saying the people will get more doctors in the state, the doctors will get lower insurance premiums if the people give up rights or have rights taken away from them. And none of that has come about. And the only one who benefited is the insurance companies.
Exactly. But another way to say that is it's like they're making a deal with you. You know, if you want your health care costs to go down, then don't sue doctors when they're negligent. Is that the trade-off you're asking for? How about let's get rid of the negligent doctors? You know, maybe that's what the legislature should have done, was focused on getting rid of the bad doctors. Oh, wait, they can't do that because we can't ever get them into civil court to show the malpractice.
Get the strike.
Yeah, and get the strike. You know, so they created a maze that nobody can get out of, and they don't ever get exposed. It hasn't lowered our healthcare cost. Their premiums haven't gone down. By their own admission, a lobbyist told us that that the crisis still exists today, that doctors are fleeing the state, when the data says something completely different. But that's the narrative that's being told to the legislature every session. And the legislature, always being made up of new people, are doing the exact same thing that the previous legislature did. Unless you had something else to add to that.
No, let's keep going.
Okay. Hang on. I just closed something that I don't think I should have. Travis, I don't know if you can hear me.
I can hear you fine.
Oh, well, somehow I have gotten rid of.
It's still shared.
Oh, there it is. Okay.
Now it's gone.
Sorry about that. I was trying to close that one window I was on. See, you can't put me in control of stuff like this, man. I mess it all up. Uh, we have heard for some time, and finally, I only highlighted this because this is coming from Representative Roach, and he's the one who made the claim. So when people say Florida's not the only state that does this, well, according to this analysis, it says right here, Florida is the only state that excludes adult children and parents of adult children from seeking non-ex. So if anybody has a problem with it, go talk to Representative Roach. He's the one that provided this information. We didn't do it.
Actually, this is the analysis,
Uh,
not done by Roach.
Yeah,
This is Roach's analysis. This is another department.
yeah. So it's not us just making the claim, that we just made it up out of thin air. It's like, this is where we got it from. You can go talk to these people if you got a problem with it. So in the fiscal analysis of this bill, there was a couple of things I highlighted, and this is where we're about to get into the Mizrahi case. The bill makes defendant healthcare providers liable in a medical malpractice, wrongful death action for pain and suffering. Okay, I'm trying to think of a polite way to say that. It covered him, it was where yeah, I think I'll
Just say it. Just say it.
I'll leave that alone. I'm not, people can figure that out on their own. And now we're into the constitutional issue, which has been one of my issues from the very beginning of this. And under the comment section under constitutional issues, they mentioned that they cite this Mizrahi versus North Miami Medical Center, and they said, let me find the beginning of that sentence. Okay, in Mizrahi, the appellant argued that the medical blah 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 blah. Since there was no rational basis to make that distinction. Okay, this is where unless you read a lot of law, and specifically on constitutional issues dealing with rights, you hear this term rational basis, and a lot of people apply the wrong meaning to it. There is a very specific meaning to rational basis when you're talking about law. The plaintiff was saying, or I'm sorry, the appellant was saying that there is no rational basis for this law to be in place. And that sounds reasonable to the average person. Then it says the Florida Supreme Court upheld this exclusion as constitutional, noting that, and this is a quote from the Mizrahi case, from the consenting justices. The statute's disparate treatment of medical malpractice wrongful deaths does not bear a rational relationship.
No, does bear.
I'm sorry. Does bear. Thank you. I was getting ahead of myself. Does bear a rational relationship to the legitimate state interest of ensuring the accessibility of medical care to Florida residents by curtailing the skyrocketing medical malpractice insurance premiums in Florida. Now, I got number one. I've got to wonder if the Supreme Court of Florida ever went out to determine if medical malpractice premiums were really skyrocketing, or were they just parroting what they've heard from the lobbyists and from others. But the important part of that quote, they're talking about the rational relationship to the legitimate state interest. The Supreme Court, I'm trying to remember what year they did this, but they came up with a three-pronged test. One is called rational basis, one is called intermittent scrutiny, and the strictest level is called strict scrutiny. The way it works, the legislature passes a law. We'll say the legislature passes a law that says this group of people can sue for pain and suffering in a malpractice case, and this group of people can't. So somebody challenges that based on equal protection and due process. So it goes to this, and this is the Florida Supreme Court it went to. The Florida Supreme Court is using a test set up by the U.S. Supreme Court. And the Florida Supreme Court chose to view it at the lowest level of scrutiny under the rational basis theory. And what that means is they showed deference to the legislature. In other words, the Supreme Court did not ask the legislature to explain itself. They simply said, if the legislature passed this law, then it must be constitutional. They must have had a legitimate state interest to pass this law. Now, what they don't share in here is Justice Pariente's dissent when she said that this law is not rationally based, and that she would like to see it brought under the 14th Amendment challenge. She didn't use the word 14th Amendment, but she said under equal protection and due process, which is the 14th Amendment to the U.S. Constitution. She also said, we don't know if the medical crisis existed in 1990, nor do we know if it continues today. And she encouraged the legislature to go back and revisit that issue. So if you want to look up Mizrahi v. North Miami Medical Center and read Justice Pariente's dissent, it will give you a lot of insight to what our side believes. There's also another case you can look up, Garber v. Snetman, and Chief Judge Schwartz said the exact same thing. That he said, in fact, he said, I would like to have seen this case be brought under due process and equal protection. So in other words, in the Mizrahi case, the attorney should have brought it under a due process and equal protection challenge instead of what they did. And maybe it would have been overturned back then.
Yeah, my fear is that this sets a precedence for applying rational basis on so many other liberties and so many other areas of our daily lives that this could really curtail a lot of our rights.
Well, let's talk about that for just a minute, Travis, because you and I have spoken quite a bit about rational basis versus strict scrutiny. And let's pick COVID, okay, since it's recently in all of our memories. In the very early days of COVID, the early weeks of COVID, before anybody really had an opportunity to know what it was, the government in every state and nationally restricted a lot of people's civil rights. And the government has the authority to do that. That's what that line means, a legitimate state interest. Until they figured out exactly what we were dealing with, the government has a right to say, we're going to be very cautious. And we're going to shut down businesses and tell people to wear masks and all these kinds of things. But according to the Supreme Court, the U.S. Supreme Court, it has to be the least restrictive, and it has to last for the shortest amount of time possible until they figure out the emergency. It would be no different than if we were invaded by another country. It's no different than when a hurricane blows through Florida and the governor is able to go in under his emergency powers and restrict certain rights. Now, under strict scrutiny, the highest level of challenging a law that was written, the Supreme Court, whether state or federal, actually tells the state legislature, you need to come explain your rationale to us. You need to tell us why you did this. And if I'm remembering correctly, there were some restrictions in Florida put in place by DeSantis early in the COVID thing. But very soon thereafter, they eased those restrictions. Am I remembering that correctly?
Correct.
Yeah. And that happened in other states as well, where the government was very cautious. We were hearing the news stories come in. Nobody really knew what they were dealing with. They said, go home, don't get around anybody till we sort this out. And once they sorted it out, in the rational, liberty loving states, people's rights were returned to them. But in the more tyrannical states, such as Michigan, isn't that where Whitmer is from? Michigan?
I couldn't tell you.
Yeah.
Don't know.
Yeah, she kept them in place. In fact, there's probably still some COVID restrictions in place in her state. But it was their way of being a little tyrant. But under strict scrutiny, the legislature has to explain itself to the Supreme Court. This is that check and balance that our constitutions put in place. Okay, you want to restrict people's rights, then explain to us why you think it's necessary to do that. But under rational basis, they don't. They just defer to the legislature. They show deference to the legislature and say, well, if they passed the law, as long as those representatives and senators were elected properly, they're speaking for their constituents, and they believe this law is necessary, therefore it's necessary. So my argument, just like Randy Barnett's argument, is it's really a double deference, because you can ask any legislator who sponsors a bill if he thinks his bill is constitutional, and what's his answer going to be? Of course it is. I would never write an unconstitutional bill. So our problem is getting the Supreme Court to review subsection 8 from the strict scrutiny level, because then the court could ask them all of the questions that we've been talking about. Well, can you prove that the crisis was real back in 1990? Can you show us what the task force had to say about it in 1988? Can you show that malpractice premiums have gone up? Can you show that doctors have fled the state? Is the crisis still existing today? I mean, the Supreme Court could grill the legislature and make them answer these questions, but we've never been able to get them to review it on a strict scrutiny level.
Yeah, if they were claiming that it's a crisis, then they need to look up the definition of the crisis and determine, is it just common economics that are in existence now? It might have been a crisis when it first started, if it did start, but at what time does it become just normality? Is that the norm if what they said was a crisis was in fact happening?
Yeah. Yeah, and again, I'll say, and this is only my opinion, and that is that the insurance companies realized they had not set, and these things are called reserves if anybody wants to look it up. The insurance companies had not set aside enough money to pay malpractice payouts when he was found guilty of malpractice. And so their reserves were too low, and they went to the legislators and to the legislature and to the legislators individually and said, we've got a crisis. And instead of the legislature looking at it the way that you and I would, they said, okay, well, I mean, you're the experts. You tell us it's a crisis. What can we do?
Go to the doctor's company and show everybody the tribute payouts. $250,000 paid for a doctor when they retire. I'm like, well, if you can throw money around like that, maybe your premiums are too high.
Yeah. Yeah. Well, I mean, that's pretty much this whole bill. Let me scroll down. I don't think there was anything else, but we just wanted to do a podcast on this because we thought it was interesting to show what, the insurance lobby, the narrative that it's created, and the medical community as well. I mean, they'll say this, but they really haven't done the research on it. Travis and I spent a great deal of time this summer reading through nearly 600 pages of the task force report from 1988. There was a preliminary report that came out, then the actual report, then there was um, a review, of it in a law review article, and all three of them total almost 600 pages, and we went through that line by line, man. And not only did the legislature do things that were not recommended, they did things that were recommended against. There was also in 1988, there was an amendment on the Florida ballot where the people were asked, are you in favor of caps and medical malpractice claims? And they said, absolutely not. It failed hugely. It failed. But the legislature still 2 years later passed this law. And, again, I'll leave it up to you to figure out how they convinced the legislators to do it. I've got my own opinion on that. But, we're just trying to share information. So, like Sabrina said earlier, so that when you speak to your legislator before they go into session in next month, and we're down to, about, I think, what is it, 3 weeks now before they go in. So look up some of this information that we've shared with you today. We've just gone over an hour, Travis, so I'm trying to wrap it up. I know a lot of people don't like long videos. Look into some of this. Feel free to reach out. You can write to Travis at legalizednegligence.com, Philip with 1L at legalizednegligence.com, or Sabrina at legalizednegligence.com, and we'll be happy to send you the information to answer your questions. We just think it's important for everybody to be knowledgeable about this. I believe this is the first year that this kind of information has really been put in their face and say, we're on to what's going on, and we're sharing the other side of the story with you now.
Yeah, they're beginning to take note.
Yeah, I think they are, especially you told me that there's been more news stories over the past year than in previous years. And, the fact that there's 5 bills between the House and Senate now.
Yeah.
Yeah. People are starting to wake up, and they realize that there's a force out here, and we're getting the word out, and we'll continue to get the word out. Do you have any parting thoughts, Travis?
No, just that, like, subscribe, leave a comment, give us your feedback, let us know what we're doing right, what we're doing wrong, what questions you have. Give us something to think about. We'll do a video on it.
Yeah, that's the part I'd really like, is people to ask us to do certain podcasts. What's interesting to you, because we'd love to cover it. We know the things that we're interested in, but it may be that other people have other questions about this stuff that we've already gone through, and we'd love to do that. One
thing I do want to get out before you close it is read the statutes. If you look at the statute of limitations, 95 or 94.11, people have the misunderstanding that you only have 2 years from the date of death, and that's not true. It's 2 years from the date of discovery,
right,
up to a maximum of 7 years. So just because you're turned down right now, the law could change. You could discover something and then maybe have a chance. Keep going through the case file, the medical records, and find something. And maybe you might find something outside of medical, something administrative like I have, where they don't give you all the documents, and that comes under a totally different statute. That could be civil rights if they're related to governmental agent kind of thing. But keep digging. Don't give up.
And that's a very important point, Travis. In my own case, I was fortunate that I come from a background of critical care medicine and transplant. And so I'm used to reading medical records. And it was easy for me to go through medical records and understand what they mean. But for the average person who doesn't understand all of that, it can take them 2 years to sort through all that and find people who will help them translate what all of that means. So it could take 2 years, but once you discover it, if you think, that whole situation just didn't quite seem right there at the end. They pushed me out of mom's room. They wouldn't let me see this. They refused, and it takes you 2 years or more to discover that, yeah, malpractice occurred. Your statute does not run at 2 years. It begins when you discover the malpractice. Or like Travis just said, if you discover something in the administrative realm, where they aren't providing you all the documents that you've requested, and you can get them on issues like that as well. So, well, Travis, if you don't have anything else to add, I'll go ahead and say thank you to everyone for joining us. I hope you made it to the end. Hang on, Travis. Once I end this, we'll chat for a minute. Have a great day. Merry Christmas if we don't see you before then.
Merry Christmas.
Bye.